As he said, my name's Chris Strobane. I'm a partner at Gilmore, Riley, Guerin, and Brown. I'm here today to talk about liability for golf course accidents and injuries. Just a little background, I have kind of an eclectic practice. I do some personal injury, civil litigation, insurance coverage issues for policyholders. I also do property tax appeals. So that'll be the second part of the presentation. So I have a little bit of everything. I know it's Monday morning, it's beautiful weather outside, so I'm sure everybody's looking forward to hearing a lot about statutes and cases and all sorts of fun legal things. So just to kind of cut through that, I'm going to try to pass through a couple issues, but feel free to raise your hand at any time and ask a question, just so I want to be able to address the concerns that you guys have. And answer some of the questions you can. I think I've hit on a couple of them, but if there's something specific to you, just raise your hand and we'll go to it. All right. Just a little bit of basics in terms of lawsuits and things of that nature. One of the things that, if you've been sued before or had issues with that, you've probably thought about the claim of negligence. And in terms of the claim of negligence, there's really four components, and I guess I want you to kind of consider those components as you do your jobs and you act in your roles at the Golf Course Association, or the Golf Course Owners of Wisconsin. I imagine you guys have some sort of position or ownership or some sort of interest in that, so it's something to consider. Duty, breach, cause, and harm. Well, what does that mean? Duty is really your roles and responsibilities in your profession. You have groundskeepers, you have your position as an owner, what sort of policies and agendas you set forth at the golf course that you work, what sort of maintenance policies and procedures, what sort of training you have for the employees, what sort of policies do you set forth for employees serving alcoholic beverages. All of those things you need to consider in terms of what is your duty to the average person who might come into contact with somebody or on your course or in your course. The breach is a step further. What if there is a failure in that regard? What if there was something that you should have done in your professional capacity that you might not have done? And when I say you might not have done, it's not because you meant to and somebody got hurt or something happened. You didn't mean to do it, but you might have made a mistake, or you perhaps didn't check on somebody else who was supposed to do something like that and it got missed. It happens everywhere, happens around the house on a daily basis. It happens in your job. So it's part of the job, and that's one of the things that we look at in terms of liability. That's kind of why you have insurance. We have breaches of the duty all the time. Sometimes nothing happens. You have, for example, we'll talk about golf carts and golf cart injuries. Sometimes you'll find something and there's some mechanical issue with one of the carts and nothing happens to it, and you discover it, one of your employees discovers it, and you've got to fix it, but it was in service for a day or two. Nothing happened. Well, that's good. There was a breach, but there was no injuries. So there's no cause, and there's no harm. In order for there to be a negligence claim, there has to be a failure for a duty that's essentially recognized in Wisconsin law. And as we'll talk about, that's a broad and great term that can pretty much encompass everything that causes somebody to be injured and causes an actual injury. We're not talking about somebody slipping and falling and nothing being wrong with them. A lot of us probably fall often and are kind of klutzy. Myself, I've taken some spills. But we're talking about actual harm where people are actually injured. It's one of the main things to look at. You've got to have all four of these for a tort. And I know there's been discussions about car thefts or theft from cars. I want you to think about all of this in terms of, when we get to that section, what would your duty be to the patrons in your parking lot? How did you fail that duty, if you had that duty, and were you the cause of the harm? their car getting broken into. So just kind of think about those things in the background when we get to that spot, because you're going to find it's a little hard to be accountable to the world, and that's sometimes what the law asks of you. Reality is you can't avoid being sued. You can't avoid having claims against you, so you've got to have good insurance, liability and excess. I recommend it because there's going to be times when you do everything right and somebody else makes a mistake, somebody else messes up. And you're going to find yourself in that lawsuit or in that claim because you or perhaps your insurance carrier are the ones with the pocketbook. Because suing people, oftentimes, if there's an injury on the golf course, suing individual people isn't as fruitful to getting recovery. I'm sure everybody's quite aware of that. So have good insurance. I encourage everybody to check and see what they have and make sure that they have not only liability, but they also have some sort of umbrella or excess. I'm sure everybody does, but a reminder. Here's where the exciting stuff comes in. The Wisconsin Safe Place Statute. That is a statute that additionally governs conduct of employers across the state of Wisconsin and sets out additional liabilities and culpability for golf course owners, employees of the golf course owner. It's a nice statute, a lot of words for a Monday. I'm not going to go into that. I have this outline that I'll email to people, but this statute's out there. There's a couple provisions about things you should do and not do. I'm just going to boil down to what you need to know or what you should consider. Golf courses are employers. What does that mean? The statute and all those words a second ago, it sets out some guidelines, some background requirements to determine what are employers in the state of Wisconsin. Employers are essentially anybody who has a property that's open to a public and you're not a nonprofit. And I would suggest that since we're talking to essentially golf course owners today, I would suggest most of the people here, or most of the businesses here, would be considered employers under the statute. What does that mean? It subjects you to an additional cause of action if there's an injury on your property. Somebody slips and falls because the sidewalk wasn't snow plowed correctly or snow blown correctly. You can be sued for a negligence claim. You can be sued for a safe place claim. The safe place claim essentially provides additional liability because employers are required to provide a safe place for all their frequenters and employees. What are frequenters? Frequenters it's a statutory term. It's been litigated, it's just tortured case law on both ends, but essentially think of a frequenter as a customer, a patron. Could also be a delivery person. It's essentially anybody that would come to your property to consider to do business, that has express permission to be on the property or implied permission to be on the property. Do you get UPS deliveries? Do you get Amazon deliveries? Those people coming and visiting your property, those are frequenters. Does a frequenter stay a frequenter the entire time on the property, if they're on your property? The answer is no. I'm sure there are private places and private areas and areas that aren't open to public walking in and using. If I go golfing, and I'm in the clubhouse, that doesn't mean I get to go hang out in the kitchen and fry up some mozzarella sticks. That doesn't mean I get to go in the basement and check out the boiler or anything like that. Those types of situations, people could lose their frequenter status. They would consider them a trespasser potentially. And that changes the liability that's out there in terms of what an owner would have. What do you do to deal with all of this? How do you keep your course and your business to be the safest place as possible? You've got to have a plan. You've got to think about it more than just always what's common sense. Sometimes you have to, because you've got employees, you've got people that work for you, you have to outline what the common sense is. What should they do? How do they maintain the property? How is the property built and constructed? How is it maintained? Is the course safely designed? Has anyone ever had a situation where anybody's injured themselves or come across something on the course that you felt wasn't built the correct way and somebody had to come in and fix it and do it the right way? There's case law in Wisconsin about cause of action under the safe place existed because a gentleman went to a tee box and was leaning on essentially a decorative fence over by the end of the tee box, decorative wooden fence, some sort of fence, leaned on it, fell down, hurt himself in some capacity. You have to plan that you have people, essentially, they call them eggshell plaintiffs, that you could be injured, what might injure a normal person or a toddler is going to injure somebody who might be a little bit more frail, who has other physical issues. This person was injured. Court ultimately found that that person could bring a cause of action under the safe place doctrine because of the negligent design and maintenance. You got to have your employees trained to recognize those things. Do you have somebody on the course that handles things that need to be fixed inside the clubhouse, inside the restaurant, inside any other premises that you have that's open to patrons? And then you have to think about on the course as well. How are your cart paths? You sir.
I'm sure every course, you got maintenance going on the course.
Yeah.
So you're out there and you're digging a ditch to put in a new sprinkler system.
Okay.
And golfer comes along and trips in the ditch. Are you liable for that?
Well, there's a question. Could they bring a claim against you, and are you liable?
Right.
Can they bring a claim against you? Sure. Are you liable? Depends on the facts. Now, if it's something that's open and obvious, open and obvious, that's a situation where you're potentially not going to be liable. These questions, what I'm trying to impart here is that you're going to have to look at the facts of every situation, because a lot of these issues, if somebody were to bring a claim against you, might make it to a jury, which means you could get sued in court. It could go to a jury because judges are reluctant to end cases at what they call the summary judgment level. They don't like to simply dismiss claims if there's a legal and factual basis for them. Now, in a situation like that, it would depend on the facts of the situation. Are we talking about somebody who tripped and fell and was open and obvious that there's something going on, or maybe somebody's driving in a golf cart and there was the ditch or the whole area where they fell was obstructed and all? It's going to depend on what that person says in terms of how that might go forward. And then you might say something that's opposite of that. And there might be expert or other objective evidence that comes into play as well. So the answer is, will a jury ultimately find you liable? Don't know. Juries are out there. What you should do is to make sure, if you have a situation where you're doing a replacement or an upgrade on the course, make sure you give as much notice of that defect as you can. And it's not really a defect, it's really just ongoing maintenance. But I don't know whether you're talking about having a sign or a notice or advising them when they come in and say, hey, on 7 there's some irrigation work, there's a a ditch or they're doing some digging, be careful around that area. Just little things like that can help avoid a claim. Another one we'll talk about in a little bit more detail. You got to have your employees reasonably trained and supervised, and we'll get to them. I imagine many of you have employees that sell or provide alcohol to others on the course. God knows when I'm golfing, I need it. But you're going to want to have some sort of training program or regimen to deal with how that's done. And we'll talk about that a little bit more down the road. Same thing as to maintenance of defects. I don't know how you guys operate in the winter. Maybe you have a restaurant that remains open. I'm not saying it's a defect, but you get, obviously in Wisconsin, we get wonderful weather in the winter. It's perfect time to slip and fall. You want to make sure that your property is shoveled and plowed and taken care of in case you have people come in on it. What does the Safe Place Statute and common law negligence add up in terms of liability? My friend Chris Traeger says everything. It could be anything. And that was essentially my answer to the gentleman here. Anything can potentially be a claim. That's why you have to do your best and be on the lookout at all times to find ways to mitigate that. I've had some cases involving some poor golf play, we'll say. Golfers endangering others. I want to point out that I'm sure, as if everybody's professionals here, you've probably got a million stories of people getting injured on the golf course by some other golfer, some other way, the Dangerfield 1,000,000-to-1 shot, and it happens. What are the facts of those? How, as owners or business holders, can you mitigate that? Foursomes, adjacent holes, driving range, all of those things come into play with golfers hitting others with golf balls. The sale and providing of alcohol as well. And you have shots like mine, stray shots, slices, hooks, hills and trees. God knows what's going to happen. All those things have a different interplay, but you really need to have the facts of those to know whether you have a claim or not. My position is, as a golf course owner, for the most part, I think you're not going to be liable for golfer-on-golfer injuries unless there is something to do with the design of the course, something to do with what an employee may have done or advised. If they got in the, if you have somebody taking a shot below a hill and you have an employee that says, oh, it's okay to hit, and they hit and hit somebody who's on the green, that might provide a different level of liability. But most of the time, if you hear a story of somebody hitting a tee shot into to somebody just down in the same hole, you're probably going to be safe in terms of liability. That golfer, maybe not. That golfer who hit that shot, maybe not. But for the most part, I think the golf course is going to be free and clear, but it depends on the facts. Always the facts. How many people here have driving ranges on their course? How many people have had the driving range on there when they bought it or put it in later? Okay. And I raise that because it's going to get into one of our other questions down the road of the design of the course. Do you put a driving range in where the balls are going to be headed towards or could potentially overlap with a busy road, busy traffic, or homes that were there before the driving range? Those are things to kind of consider in terms of what liability would be, and they could bring a claim if there was a claim somehow for a negligent design. if something like that became a problem. I'm just talking hypothetically. I'm not saying that that is something that happens or could happen, but I'm just encouraging you to think outside the box in that regard. When you're doing things, you have to consider what your duty might be in Wisconsin. Wisconsin is called essentially a Paul's graph state. What is Paul's graph? No one wants to know. It's a minority opinion in a New York court that they teach in law school. But what it means essentially in this case is you have a duty to everyone. So you have to consider yourself as having that duty. The other end of it says it's only reasonably foreseeable. It's a duty to only the people that you see as reasonably foreseeable to be injured by your conduct. That's commonly seen in Wisconsin as a public policy argument. It's great, but you don't want to get to that point because that means you're in court and you've got a lawyer writing legal motions, and that's no fun for anybody. Residential homes. Maybe we won't have that clip today, but I have a picture from Happy Gilmore. We've all seen this scene, or if we have, I'm sure you guys have been a golf movie. Nobody here has seen Happy Gilmore. But in this one, Happy is challenged to a little driving contest, and he takes a shot or two at the lady down the hall, or the lady in the house down the street. And so they're challenging his driving prowess. There, he's obviously intending to hit towards the house. He could be found liable for that. And eventually he hits her. She falls out injured. It's an intent or mistake. Here, they're not on a golf course. If you're on a golf course and you've got a subdivision that's near you that pre-existed your golf course or was built during when your golf course was there, and the golfer hits the home, is the golf course liable for that? What do you think? Think of duty, breach, cause, and harm. If you've got, let's say 7 is, hole 7 is next to a row of condos that were built after the golf course was there and people moved in knowing there was a golf course there. Do you think you guys are going to be found liable? I don't think so. I don't think so. If the golf course pre-existed or was there prior to the homeowner being there, or the homeowner moved into the house or the condo knowing there's a golf course there. A lot of people move in to these homes because it's nice to be right next to a golf course. It's good scenery. Maybe they like to golf. There's in Wisconsin something called an assumption of risk. When there's a lawsuit filed, it turns out to essentially be comparative negligence. But if there are golfers who are hitting shots into homes, and that's the way the course always was, I would suggest that you're probably not going to be held liable. But it's something that you're going to need to consider if it becomes an ongoing problem as to whether there's something you could do in terms of the design of the course or something should be done in the design of the course. Would I suggest building a driving range next to a row of homes that are there if you have some free land, so to speak? You may not want to do that. That might be a completely different case. But if you're talking about just one of my tee shots, you're generally going to be okay, I think. Golf cart accidents. Go ahead.
So the house does get hit, it's more of the homeowner's responsibility to find out what golfer hit the house and go after damages?
I would suggest that's probably the best thing to do. I'm not going to say the homeowner can't say, well, this is your fault. I don't think that it would be. That's what you might have insurance for. But that homeowner should have insurance too. I guess what I would say is it might be a good idea. I mean, if you keep track of who's golfing, that's a good thing to have. But if you encourage people, sometimes you like to think people are nice people. If you're going to you're going to hit a house, you're going to break a window, you're going to, walk over and say, hey, I'm sorry, I hit this, I hit this, tee shot into you. I think maybe I broke something, or leave a note. But I don't, I don't think you're necessarily liable for what the golfers have done. I think they've assumed the risk in buying a property that's on or next to the course. That's assuming, of course, that you're not having a situation like we had talked about with Happy Gilmore earlier, where they're setting, it's not a bachelor party setting up tee shots to be funny. That's why we have to get the facts of the situation, because if it's a situation like that where we're taking bets if we can hit the house, and you don't have a groundskeeper or marshal or somebody to make sure that type of stuff isn't happening, then you're going to have an issue. So again, we get to the facts. What is it? Here, supposed to be some clips of really some poor golf cart driving, accidents and collisions, alcohol, cart maintenance, course maintenance, things to think about. What sort of policies do you have about selling alcohol to people driving golf carts? Do you have cart people that go on the course and sell beverages and refreshments? Things to consider in that regard, because I imagine a lot of these accidents and issues, they happen when people have had, a couple drinks. Usually when you might think that you don't become a better driver after you've had one or two. Not that good sense of driving where you're feeling really good and you're, the old Peter Griffin logic. Cart maintenance. How often do you have the carts inspected or maintained? How do the brakes work? How do the gears work? How often do you check those and make sure that they're working safely? I would suggest that's something you might want to have a policy or procedure to do it pretty often. Have somebody to check that, who knows if there's issues, or to try them out and make sure that they're safely operating. You don't want a situation where somebody's going up a hill and something gives out and it heads backwards down the hill, or vice versa. You want to make sure it's not the cart's fault. Of course, I mentioned cart paths earlier. Are any of the areas where the cart paths that you have on the course worn down? Are there any that are at a really tough or a weird angle? How do you handle cart paths on the course when it rains? Does that make the situation a little bit more dangerous for the golfers? Those are all things that you have to consider in terms of how you make policies on your course. Here is essentially a crash video. Picture at the end shows what you need to know. I don't know if you've dealt with or have situations where there's a lot of shenanigans going on the golf course, people ramming into each other. I don't know, bachelor parties get out of hand, racing or doing what, but it's just a reminder that these things, they're nice, they're fun to drive around on the course, but they're not exactly the safest vehicles you could be in. Go ahead, sir.
How effective are, if you have somebody sign a waiver before they go out there? Okay,
Go ahead.
Piece of paper basically say, I as the driver of this car, assume the responsibility for, I won't sue you if I wreck the car.
Okay.
Or have an accident.
I'm glad you asked that question. I'm glad somebody did. I was going to kind of raise it in a side comment. Waivers and exculpatory releases. They're things that you can have. I mean, you can give people waivers to sign. I'll tell you, waivers in Wisconsin have traditionally been viewed with disfavor in front of the courts, but that doesn't mean I haven't seen them held up in some situations. The key to having a waiver, though, is having it that is drafted with certain particularity to the specific type of injury that you're talking about. Do you have a waiver in regards to? I wouldn't say, okay, let's have a waiver, and they call it an exculpatory release. You come in and I'm looking to golf. You have a waiver that's one sheet of paper that says that I recognize I can be injured by anything on this golf course, and you will not hold the golf course liable for anything here. That's probably not going to work. You would need to have a specific waiver that outlines the risk that you're giving up in terms of what you're paying for to use the premises. Is it related to golf carts? Is it related to the maintenance of the golf carts, or just the operation of the golf carts by the the person using it? Does it relate to other people driving golf carts? What if your cart person loses control of their vehicle and rams into the golf cart? What if somebody else who doesn't sign the waiver for some is driving it and causes the injury, right? You have to have, if you got to force them, are all four people going to sign the waivers? So there's a lot of little issues that you have to look at to make sure that the waiver holds up. And then what sort of injuries? You got any physical injuries? You have to be very specific with these things so they hold up under a court scrutiny. I had a waiver case once where involved a tattoo and a tattoo artist. And essentially the waiver said, any sort of reaction or issue with the medicine or the tattooer after this, you agree to not sue the shop or the artist. I filed the motion in court, and they let it get passed. They denied it. They said, we tend to disfavor these things. So things that you think are simple and solve the problem, much of the time they don't, unfortunately. I thought I'd win that case. I didn't win the case. So ultimately had to settle it. It was just an infection over a tattoo. And it was right in there. Go ahead, sir.
I've got a question about the driver of the cart and age.
Okay.
Many years ago, we had an attorney represented the golf course that was adamant that driver's license and 18 years old. And that's kind of stuck with me for a long time, and most of the time that's been the policy. I've never really had a problem talking owners into that. But what's your opinion on that? Because every now and then somebody special will have their high school golfer out and say, can't we just bend the rules for this perfect kid?
Mm-hmm.
And
aren't they all perfect?
that lawyer at that time said, if you have an issue, your exposure with a minor is a lot different than an adult. What's your thought on that?
I guess if they're licensed, if we're assuming that they're licensed, and they're with the parent, I'm not going to say never. I don't think it's.
Typically, this would not be with a parent.
Oh, I would.
They have a license and they feel that they should be able, if they can drive a car to the golf course, why can't they drive a golf cart?
I guess I would say you can make the policies that you want at your course. I don't know if that necessarily increases your liability. I would say it might, just because it's a unique type of driving situation and they're young drivers. I don't know if I want to say greatly, but if something catastrophic happens, I could see a lawyer saying, well, this person hasn't been trained that well on this, and filing a case, and he tipped it over and it rolled down the hill and there's serious injuries. You'd rather not have that as a case, and somebody would probably bring that. But
Does 16 or 17 differentiate from 18?
I don't think so. I mean, 16 it sounds younger. I mean, it is, but I just they're young drivers. I think if you want to make a rule that only 18-year-olds can drive the cart, that's something you can do. I mean, what was it, rental car companies for all those years? You had to be 25, something like that. So you might. Case by case basis, I guess it depends on how important that person is. Maybe you want to have somebody kind of watching him. If it's a 16-year-old and a bunch of their friends, you probably want to be watching him. Who knows what's in the golf bag? We'll get to that because that could be another issue. We'll get to that because young people on the course, they present a different type of challenge if they're anywhere like me. All right, we've touched on this, and we can go back to golf carts and stuff if somebody thinks of something else. I've tried to suggest think outside the box in terms of injuries that could happen because injuries always seems to be stranger than fiction in terms of real life injuries that I've come across. And had my thing been working correctly, I'd be showing you a swan attacking Larry David on the course and him beating it down with the golf club. That's one. Larry David, he's on curb. New season started last night. I'm sure everybody knows he likes to golf. Going back to one of the classic movies, Happy Gilmore, I don't think anybody has any alligators on the course here. If you did have an alligator on the course, I'd be concerned about that as a course hazard. I don't know if anybody else has any sort of animal issues with coyotes or wolves or aggressive birds or anything like that, but course hazard, if you know about it and they're out there and somebody can potentially be injured, something to consider. Now, another situation in terms of a course hazard, and if I'm trying to get my PowerPoint here to work, and I'm sure nobody's ever seen this movie before or heard about it in terms of the golf world, but Caddyshack. A lot of the Zoomers and the young people in my office, they've never seen Caddyshack. Most of us grew up with it in some shape or form. But does anybody remember the scene that I never got it out of my head as a kid? Was when the bishop or the priest was golfing in the rain, right? And Carl Spackler, as he's wont to do, he's got some wisdom in him. Thought, the rain, the heavy stuff was coming down, a little bit later, keep going, right? He's having the best round of his life. Do you guys, or when I say you guys, I say this colloquially to everybody, do you guys have any sort of policies and procedures in regards to rain and thunderstorms on the course? You're nodding. What do you have?
We have two courses, and one has GPS, so if there's lightning, we'll send out a warning and ask golfers to get off the golf course. And then the other one would blow a horn.
That's good. That's excellent. The other one, if I remember in Caddyshack, and the clip said it was just a nice gentleman in a umbrella saying, "Hey, why don't you get off the golf course?" Maybe you want to consider that type of thing with a waiver, having that in there, a weather injury of some situation. But do you have one of these policies or procedures? Go ahead, sir.
Question, but what do you do when you have severe weather? I've actually driven my truck on the course, thunder, lightning, the sky is blue, trying to get these people to get off the course. Like, oh, we're just going to finish this hole. I said, well, let me notify the next of kin because I wasn't going to sit up. What do you do? People leak on.
That's tough. That's where you might want to say, maybe I want to have an exculpatory release of some sort, specifically designed to talk about weather or lightning strikes and whether, when I say weather, they've been notified by course officials to get off the course. Do you have somebody in charge, other than, including yourself, to go out there and get these people off the course? you got to get them off the course. If they won't get off the course, that becomes on them. Wisconsin's a comparative negligence state. You want to have record of you going out there and warning them, warning those people specifically. Maybe you have a release. Then perhaps you have a public policy argument or some sort of other argument, at least to defend yourself in court in that regard. Gentleman with the beard back there.
I've heard just the opposite, that if you don't have a lightning detection system, that, who are you to know that it is particularly dangerous weather and that you need to get people off the course? And if you post that everybody is under their own responsibility to make that decision, that's what frees you from the liability.
I got into that argument with our head golf professional because he said the same thing. He's like, no, we're not weather people. We shouldn't be advising. So I called our insurance company, and they advise us to do whatever we possibly can to let people know, because they're of the opinion that since we made a good faith effort, then it's up to the golfers that don't come off the golf course. He's like, because Wisconsin is a kind of a no-fault state, like you did your job, and they didn't listen. So it's kind of on that.
But what if you decided, or whoever was in the shop at that time, it might not be the golf professional or manager, decides that, okay, it's not that dangerous.
Well, does that person have the right qualifications? What sort of policies or procedures as the owner of the course have you set up to ensure the golfer's safety on the course? Think about, this is where we go back to the safe place statute. But this is where you go back to Wisconsin being the Paul's graph state. You have a duty to essentially everyone. I think I would be concerned about not having any sort of protection system in place, because that's something that they could, put in a complaint pretty easy in terms of negligence. You got to have, I think, something. If you've got a horn, at least, some sort of a blowhorn, or you've got an official that if there's lightning warnings, going out, driving around the course to advise people, perhaps a text alert system of some sort. If there's golfers there, you text them with a warning that there's lightning in this area or that area. You can never go wrong with additional warnings or notice, in my view. You get sued, it gives the opportunity for a jury to say, this person who was out there should have known better, right? They tried to warn him. Wisconsin's a comparative negligence state. What does that mean? It means that juries decide liability on a percentage basis. 50-50, somebody gets a $100,000 verdict. If there's 50-50 in terms of negligence and liability, a portion there, that means that you or your insurance carrier only has to pay out 50% of those damages, so $50,000. Now, if the person who is injured is found to be 51% at fault and you're 49, pay zero. So that's the fun of comparative negligence. Plaintiff's lawyers don't like it as much. I'm a plaintiff's lawyer a good deal, but I'm also a policyholder and business lawyer too. It's helpful, and it's helpful to know, and that's why I say any bit of notice or onus you can place back on the person who might have been injured. Say, you should have known better. Or, you're a reasonable person. You've, 40 years old. You know what lightning is. You've golfed during this type of weather. You should know.
By having some policies in place, wouldn't it put the course at more risk? Let's say the policy is that an employee has to go out and warn the groups. Obviously, at that point, the liability to the course for the golfer is gone, but now it's a situation where you actually forced an employee to go out in weather to warn a group. Or,
Counterpoint, would you rather have an expert course professional come in and say, a reasonable golf course owner would say, and they have expert witnesses, and there will be expert witnesses paid to come in and say, they should have had policies and procedures in place to protect these golfers. Now, juries might be a little bit more lenient towards somebody who's made a good faith effort. Perhaps the 16-year-old kid didn't go, warn the 18th hole, but there were some policies or procedures in play. He didn't personally warn them, but they got a text alert, or they heard the foghorn, or whatever it is. So they had some ample opportunity. I always suggest you should have, it's good to have something rather than nothing. I probably won't get this finished until the break. I'm not sure how we're doing. We're doing all right in time. I do want to get into a point about social host liability. Has anybody ever heard of the social host immunity, that statute, in terms of selling alcoholic beverages? Some people think about the Dram Shop Act and things of that nature. Who sells alcohol at their golf course? Right? Have you ever thought about how the selling of that alcohol might contribute to golf cart injuries, and whether you could be held liable for over-serving somebody? That's a concern to think about. Or getting off the course. You know, somebody's had 8 or 10 beers in them, and they get in an accident. Social host immunity protects owners and business owners in those types of situations generally. I still wouldn't trust it to save you at the end of the day. So you have to have some protections in that regard. So pay attention to who you're serving. Go ahead.
Now, what if your course only sells them a couple beers, but they have a bottle of whiskey in their golf bag and they get all busted up?
That's one of the reasons why they have liability. You know, they have the immunity. It's social host immunity. Normally, under those circumstances, you can't be held liable. If there's a situation where you see somebody driving around intoxicated, and you know they're intoxicated, and walking towards a car or something, that might be something where, you know, you don't want to call the police on your customers, but it's definitely something to consider. I had a beautiful picture of McLovin here too. We all remember McLovin from Superbad and his fake ID. We all remember that scene. One of the exceptions to that is serving minors. And as I think there's nothing more innovative than a minor trying to get alcohol. And so going to a golf course and having a fake ID and getting alcohol could slip into an exception of social host immunity. You have a situation where, you know, the perfect 16-year-old wants to drink a few beers, or buy a few beers, or sell a few, or have a couple of beers sold to them. That's going to take you out of the social host immunity. Okay? Essentially, they have to provide ID that you can reasonably believe they're over 21. McLovin, obviously, that was an example of, obviously, it's, you know, McLovin. He's not of age, but it's something to think about in this case. I might have hit most of the issues. We've talked about most of the things. The car theft issue, I know that's been some concerns. I would be less concerned about that, more concerned about other sorts of injuries or things happening in parking lots. I don't know if anybody's ever had fights in the parking lots, things of that nature. If you know you have a problem in the parking lot, that puts you at a greater risk of liability or culpability than if you never had an issue. Right? If we think of everybody's seen the movie Roadhouse? Anybody with Patrick Swayze, classic there? You know, he's be nice, and then it was a rough place. A lot of police calls, things of that situation. If you have a car theft, you know, every week, and do nothing about it, does that make you more liable or less liable to your patrons and people you market your business for? I'd say you'd have to consider that. Do you have any protections there? Do you have cameras at all? Do you have anybody who monitors the parking lot? Those are all things to consider. Do I think you're normally liable for stuff like that? No, but you're going to have to think about the facts of it. Has your course been hit with a lot of thefts? Is there something that you reasonably could have done to protect the vehicles? I often think about, you know, what if anybody's got a golf bag or the golf bag pickup or layoff? You just walk up there and pretty much pick up whatever bag you want. I mean, how do you match up those people with the right people? And who steals golf bags? I know, but I'm just those are things I think about. Last point I think I was going to have was your employees. Now imagine a nice, beautiful picture of our friend Carl Spackler again. Would you want to hire a guy like that to maintain your course? On one hand, yes. He's fun. He's golf with the Dalai Lama. On the other hand, no. He's probably going to blow it up looking for gophers. That's kind of a far-fetched idea of it, but I would suggest that you have other situations where you need to think and do background checks on certain employees. The bartenders, the people in the pro shop, the people doing, working with the patrons, selling alcohol. Do you do background checks? Have you done criminal background checks? Have you checked references? Those are things to make sure and double check to make sure that they're not they weren't fired from a previous job for harassing other golfers, right? Or harassing other employees. And think about that, because you're going to have to train those people, and ultimately you're going to be responsible for those people if they act in a negligent way. So, and with that, I think we're at 10 o'clock. Any other questions? Right now, I'll answer some more. Yes, go ahead.
Question on employment law. A lot of seasonal employees that are terminated 9 months and then are into a rehire.
And they're what?
And they're rehired the next season.
Okay.
Termination of regular employment and then they're rehired. The importance of re-signing an employee handbook, the importance of acknowledgement of policies and procedures that have changed, and the importance of I-9s, again, back to the golf course.
Yeah, I think those are things to get. It's always important to
Each year,
you should, yeah, because you might have different policies every year. I mean, there might be a situation where somebody slips and falls in the shower for some reason, so you have to do this type of cleaning or this type of thing. Aspect of their job might have changed. So I think it's safe if they've left the employment, you should have them re-sign it, and then if there are substantive changes to the policy handbook, then you send an update out and have them sign that and give it back to you too. And that protects you a little bit in terms of you've definitely tried to train these people, and you're trying to supervise these people by letting them know about these policy changes and updates. So that's a good point.
Is there a blanket statement you have on the scorecards where they're telling the golfers they're assuming some risk by being on the course and the course is not responsible, or?
You could. I don't think it's going to hold up. I think it's got to be a very specific waiver or release. You probably want to have somebody try to draft it, but it's not going to be bulletproof. I think you've really got to pick out certain areas of protection for the golf course. Lightning.
Frivolous lawsuits, where something happens and they try to make a big deal about it when it's their own stupidity.
It happens all the time. Happens all the time. Anything else?
If I may say, just because we get from golf courses all the time, going back to the rehiring of employees, it's a best practice to call your insurance agent to have them run then an MVR on that employee once again, if you have in the past, in the first place. It's to all the golf course owners' benefit to have that done on anybody you hire, because they're going to be out there driving those carts. And if so, in fact, there is somebody that maybe had a DWI that isn't allowed to drive anyways, they also shouldn't be driving your carts around. And yes, a warm body is sometimes what you need out on the course, like every other place, you need somebody. But it has come into play to where somebody can't drive because of that issue, and then you still have them on course, and then something happens. That's where a big liability issue could happen for the golf course. So any new employees, any rehires for the new season, definitely should call your insurance agent, have them run those through, and then you guys know you're safe.
All right. This gentleman.
So we had in few instances, we had people basically messing up with the cards, where they open the card and mess with the governors to make it go faster. And they might get hurt, they might break the cards. Like what can we do in that kind of situation?
Well, if they're doing something like that and they damage the carts, I think they're potentially liable for property damage to you in that situation. I think that would, if somebody's messed with the governor and then causes themselves to be injured and brings a case against you, you might want to have that well documented for your defense too, to show that they made material changes to it, drove it in a reckless manner, acted recklessly in changing the design modifications of the cart. You want to definitely have that documented and recorded.